Okay, good morning, everybody. Thank you for joining. We're pleased to be able to partner with FEMA Region 9 on this contracts webinar. We appreciate FEMA Region 9, Angie Saavedra, for participating with us and giving the webinar, as well as our DEM Deputy Attorney General, Samantha Laddick. What we're hoping to accomplish is to remove some of the confusion surrounding contracts for your FEMA grants. So please be sure to ask questions that may come up during this. And at this point, I'm going to introduce Angie Saavedra from FEMA Region 9. She's the Director of Grants Management Division at FEMA Region 9. And thank you so much, Angie, for putting this together for us. Go ahead and just say next slide and I'll change for you.
Okay, great. Thank you so much, Janelle. Appreciate it. Are you're able to see the slides, hear me well, and can you see me? Just maybe a couple thumbs up.
It's working.
Okay, perfect. Thank you so much. All right. Thank you, Janelle. Appreciate the invitation. Again, to continue discussing procurement under grants, which we know is a pain point for all of us in terms of managing grants. So appreciate the opportunity to be here with you today to provide some background information, but then also to make the connection. Importantly, I think with these trainings, they do provide really great information. At the same time, I think we recognize that it's an hour and a half, 2 hours of your time. And so none of us are going to walk out experts from a presentation such as this, but really the hope is that it plants a seed that you're able to, as you're going through a procurement and you're walking through, in this case, developing the contract agreement with your selected contractor, that you have little light bulbs go off of, I remember them discussing X, Y, and Z. Let me go back to their reference documents. Let me go back to the slides, or let me reach out to my points of contact to make sure that I'm doing this appropriately. So appreciate being here. As Janelle said, my name is Angie Saavedra. I'm the Director for Grants in Region 9. I have been with FEMA since 2014, primarily at headquarters. I came to Region 9 in 2020. And I'm a lawyer by training, so I've worked with grants both from a legal perspective as well as a programmatic perspective. So I have both points of view to be able to inform how we provide guidance and how the team provides technical assistance. With that, as Janelle mentioned, Samantha Laddick is also here, and so I wanted to take a pause so that she can likewise introduce herself.
Hi, everyone. My name is Samantha Laddick, and I am the legal advisor to the Division of Emergency Management and Homeland Security. I'm here today because I have a role in the contract review process. And so not only did I want to hear what Angie has to say so I can learn too, but I wanted to be here to talk about our process as well. Thanks for giving me the time to say hi.
All right. Thank you, Sam. So next slide, please. I think Janelle might be getting a delay on my end if you did move the slide. Oh, there we go. Okay, thank you. So the game plan for today, as we mentioned at the very top, we're provide some general knowledge on procurement contract provisions, those that are required and those that are recommended. Hope that we increase your awareness of when they're applicable, because there is some distinction in when you will use some versus others. And then importantly, this is the biggest takeaway, is that you learn about the available tools and resources. Again, I think not everything's going to be burned into your brain based on this training, and the key really is you knowing where to seek assistance, whether it be through the websites or through the points of contact. Again, next slide. And some of these are active Or animated, Janelle, just for your awareness.
Sorry,
All
Angie.
right.
There's somebody in here. Did you say next slide? I'm sorry.
Yeah. This is an animated one, so it's like the other side of it. All right, so while Janelle is going through that, some of the hot topics that we're going to discuss are the reason why we have these requirements in place, the support that you can expect from both FEMA and Nevada, and then we'll go through some of the specific contract provisions that are mostly relevant for you all as mitigation subrecipients. Next slide, please. All right, so with that, we'll start with why is this important? Why are we here talking about this? Next slide. So as we're thinking through why this is important, this is general with procurement under grants, as I mentioned at the very beginning. This is an area that ends up giving a lot of challenge to subrecipients and recipients alike, and also ends up being very costly. And so this is a figure from fiscal years 2010 and 2017 from OIG audits. It's the figure that is most recent. We have to update them based on the latest data. However, I'm expecting that that number keeps on going up. So $806 million were potentially ineligible contract costs due to non-compliance with procurement under grants provisions. This is all of procurement under grants provisions, not just the contract, but with the next graphic that we'll see come up, you will see that missing the required contract provisions ends up being one of those bigger culprits, if you will, in terms of why costs are questioned by the OIG. So Janelle, you can click. There we go. So as you see, following up in competition is the biggest concern, but if we have one more, the missing contract provisions is up there in the top 5 in terms of issues that that we see often with procurement. And it's a really easy one to solve, but it's one that if you don't address up front, one, it can have the OIG or us question your costs. And then when the OIG question costs, 69% of those findings, when they question them, do result in the OIG recommending a complete deobligation. And this is just from the OIG funding, as you know, findings. As you know, the OIG doesn't audit every single project that is out there, every single subgrant that is out there. FEMA also has to do a thorough review at closeout. And so we also find non-compliance, as does Nevada. So Sam is here and she also does those reviews. And so those are things that we've identified really are a pain point and can put your contract costs at issue. And I think that the biggest concern there is certainly oftentimes we find these things after the fact. So Nevada, FEMA, the OIG, we don't find out that these things were not correctly done until we request the documentation or we're going through everything, and then we identify that there are issues. At that point, you've already entered into the contract, you've already paid out the money, and so if there is a deobligation, it's not like you can scrap the project, the money's already been expended. And so a deobligation is even more of a hit for the budget, because then that is money that the recipient or subrecipient needs to come up to make whole when there is a deobligation. And so that's what we want to avoid. I think we want to help you not just get the money, but keep the money so that you're avoiding any headaches such as this on the back end, because taxpayer funds were not properly safeguarded. And that's also another big takeaway. I think we talk about federal spending, we think about big government, but at the end of the day, this is money that we all pay into our taxes, right? This is federal taxpayer dollars. This is your money. This is my money. This is what we all do in our civic duty. And so there is a very real, I think, practical impact for all of us when federal taxpayer dollars are not spent correctly, when we're not protecting them. And this is part of the reason why these rules are here, is to make sure that we're protecting taxpayer dollars, which are your dollars and my dollars. When we don't, and there is waste, fraud, and abuse that results from this, certainly, you know, it's as we know right now, we're going through the funding discussions at Congress. It's a finite pot of money. And so the implications are that either there is less money to go around, or programs get cut, and those two things are both negative. And so we want to make sure that that we're not contributing to those negative consequences for ourselves. Next slide. All right, so just setting the stage. I think many of you know this, but the required contract provisions come from 2 CFR Part 200, and specifically 2 CFR sections 200.317 to 327. So there are 11 provisions, and one of them is the one for the required contract provisions, which is 200 CFR 0.327. So this is the basis for this requirement. One thing that I wanted to note is that these rules apply to all grants, not just FEMA grants. And so these rules are issued by OMB, the Office of Management and Budget. That office sits within the White House. And the rules at 2 CFR, including the procurement under grant rules, are rules that apply to any grants that FEMA provides, but equally any grants that you might receive from HUD, that you might receive from the EPA, or from other federal agencies. So these are equally applicable to any grant that is out there, including FEMA grants. FEMA does not have any discretion to update, revise, or waive any of these rules. Next slide. And the objectives, we already talked a little bit about this. The objectives for these rules are to get the most reasonable cost, to make sure that we're protecting those taxpayer dollars, and there are other policy considerations as well, where we may touch on some of those other policy considerations, but it's really about protecting that federal taxpayer dollar and getting to a reasonable cost. Next slide. Thank you, Janelle. All right, so one thing to note is OMB did recently update the rules. And so November 12th, 2020 is the key date that you want to know here. Any grants that were awarded prior to this date or are related to, if it's, for example, an HMGP grant, that are related to a disaster that was declared prior to November 12th, 2020, the older set of rules is going to apply. When those older set of rules also found at 2 CFR, but they were 2 CFR sections 200.316 to 326, I believe, or 317 to 326. There were just 10 rules. Post November 12th, 2020, they added one more, and so we are at 2 CFR sections 200.317 to 327. So post November 2020, we have 11 rules. Pre-November 12th, 2020, we have 10 rules. They have the same numbers. Some of them, they overlap, and so it can get a little bit confusing. Just a tip in terms of what I use to make sure that I'm looking at the right set of rules. I look at the date, then I go to my favorite search engine. I type in 2 CFR Part 200, and typically the first search result that will come up will be an ECFR website, which is a government website that has all of the regulations there. So if you click on that, that will take you to the rules. And then on the left-hand side, there will be a menu that includes a date. If you plug in the date, let's say your award or your grant was awarded on April 2020. So I plug in April 12th, 2020, which is the date. I put go to on that date, and it will give me the rules that were applicable on that date. So there's not a guessing game. So you can use that ACFR tool to make sure that you're using the correct rules. And this is especially important for these because they have the same numbers, but they're a little bit different. And there's some additional requirements that are applicable for post November 2020 that were not applicable pre-November 2020. With the contract provisions, Generally, all of them still apply. The one difference with the contract provisions is that under the old rules, the contract provisions were found in 2 CFR 200.326, and the old rules and the new rules, it's 2 CFR 200.327. All right, and we'll go to the next slide, please. All right. One of the things that I mentioned at the very beginning is that we're going to talk through the respective roles and responsibilities that each of us have as it relates to procurement. Next slide. So we'll start with FEMA. What's our role and responsibility? FEMA, like you all, we also have obligations under 2 CFR Part 200. FEMA is responsible for making sure that we are safeguarding taxpayer dollars, that we are enforcing compliance with the rules, that we're tracking compliance, that we're monitoring, but also importantly, that we're providing technical assistance and guidance such as this today. So ultimately, our responsibility is more directly with the state. So we will work directly through the state, the recipient, and then the state and will work directly with the subrecipient. So our primary responsibility is to the state, to the recipient, to ensuring that we are safeguarding the rules, that we're protecting, safeguarding taxpayer dollars, that we're enforcing the rules that are at play, and that we're providing technical assistance and support. And then when we do find a non-compliance, that we are ensuring that there are corrective actions that address the non-compliance. And at times, unfortunately, which is again what we want to avoid, we have a responsibility to deobligate where there's a non-compliance, especially if it's an egregious example of a non-compliance or if it's something that's habitual. So those are the responsibilities that we have. Next. And now the Nevada role and responsibilities, and Sam is here and she'll be able to talk through those.
Janelle mentioned that Heather might want to start this off. Heather, are you there?
Yes, I am here. Can everyone hear me?
We can hear you.
Great. Okay, yes, I'm Heather Sanani, the Mitigation Management Analyst here at EEM, and I am the one that handles all the grants and I review the contracts. So yeah, to touch on this topic from the state standpoint, when you submit your quarterly financial reports for reimbursement and you have the budget category for consultants or contracts, and then you submit the invoices for reimbursement, we are always going to ask for a signed copy of the contract. So just to let you know to be aware of that and be prepared for that. Then when we review the contract to ensure it contains all the required FEMA contract provisions that apply to the contract, we use a checklist that we created internally. And I can attach this in the chat. It's a good quick reference to see what provisions apply to your specific contract. So not all of the provisions apply to every single contract. Specifically for professional services contracts, they do not require all the provisions that are specific to construction contracts. So there are some differences there. Additionally, we are going to ask that you submit all of your procurement documentation to show the history of the procurement and how you went about obtaining the contractor or the consultant. What we're looking for with this request is the RFP or the RFQ that was used. This is for all contracts, construction contracts and professional services contracts. We're going to ask for the scoring and or the ranking sheets that were used for the selection process, and then the 3 informal quotes or cost estimates. This is needed for every single contract, no matter what the dollar amount is, as DEM requires this starting at a $0 threshold. And I can attach the memo, the DEM memo that's related to that as well in the chat. And when it comes to the addition of the required contract provisions for your contract, you don't have to completely change the contracts that you typically use. If you have standard contracts in your agency, you can just attach the provisions to the end of the contract. This is acceptable and works just fine. And those provisions that apply to your contract, you only need to attach those. Just ensure that they're part of the overall contract and that they're assigned as part of this. And lastly, we do want to mention to everyone that we are available to review your contract before it's executed and before it's procured. We can do this here at DEM to ensure that it includes all the contract provisions, the required contract provisions for your contract ahead of time. And this is helpful so you don't have to then do like an addendum after the fact. And basically, I just want to reiterate this, that the goal of this webinar and our contract review process internally at DEM is to get you reimbursed for your contract expenses. And we just want to ensure that you meet all the requirements and that it's a smooth process. That's all I got. Thank you.
Thanks, Heather. And this is Samantha Laddick with the Nevada Attorney General's Office. I just wanted to chime in and kind of let you know kind of where I fit into the process. As they mentioned, the grant team will go through your contracts, compare it to their spreadsheet to determine if it has all the required provisions of CFR. If they find that there are some missing sections or some parts that don't quite look right or they have questions, that's when I get involved. They send it to me and I do a second review. I go through your contract line by line with my own checklist and just make sure that everything that's required to be there is there. If it's not, it results in a memo from me to them, just outlining, what's missing and providing recommendations on whether those issues can be fixed or how to possibly move forward. That memo goes to the grant team and it goes to the chief of DEM, and then it's at that point it's really out of my hands. But I just want to tell you how exciting it is to have all of you on this call today, because lately I've been getting a lot of contracts, that were signed years ago. And when I review them and I see that they're not compliant, it's literally the worst feeling in the world, because everybody on the state side wants to reimburse for these contracts and wants to reimburse for these projects. And so I'm really glad everybody's here and they're taking the time to learn what's required in the contracts. One thing you may not have thought of is the DEM is also subject to the same provisions that you are. So we've been through this as well. How do we take these form government contracts and make them compliant with 2 CFR Part 200? And what I will tell you is, I think you all probably would agree with this, but changing a form contract from the government is almost impossible. So we have taken the approach of creating what I call a federal funding attachment that we put on the back of all contracts that use federal funding. You got to be careful. It can't just be something you slap on there every time and don't look at it. But it definitely gives you a place to start, and it saves you time, rather than starting a whole new project every time you get a contract. You at least have a basic list of everything that should be in the contract, and then you can tweak it if you need to. It just saves you a bunch of time. So anyway, I will be part of the process. I'm here if your legal has questions about how to create an attachment or wants to talk through any of those issues. My contact information is at the end of this presentation. Feel free to share that with your legal. And I guess this is kind of already been said, but please get your legal involved. This is something, it can have major repercussions if you don't have compliance in your contracts. And so we just want to make sure everybody has what they need, and we're here to help. So that's all I'm going to say for now. Thank you.
Oh, I'm on mute. Thank you both, appreciate it. And this is a perfect segue, because next is what are your roles and responsibilities, and what's your role and responsibilities? And we already mentioned some of that is you are charged with knowledge and understanding of these rules because you have accepted federal grant money. And so regardless of whether you have studied them in detail or not, you are still charged with knowing about them and with complying on them. And so this is where this type of training, technical assistance and support, and just a quick review of the reference documents comes really important, because no matter what, you're going to have to show that you complied with the rules. And in this specific instance, that you included all of the required contract provisions that are applicable based on your specific circumstances. So you will need to show that this rule was complied with. And as our colleagues in Nevada have said, it's something that they will review for. And it's likewise something that FEMA at closeout will review for. And so the biggest thing is, yes, sometimes we can address if we catch it early through an addendum. But as Sam mentioned, when we're looking at these contracts way after the fact, the work has been completed, hammers down, it's there's no revising anymore, right? Because it's already been done. And so there's no way to cure a non-compliance with contract provisions if too much time has passed. So it's also important to recognize that if you don't get your legal involved early on, that if you're not proactive about this, there can be consequences. And one thing that I wanted to just also foot stomp and clarify is that while all of us, Nevada and FEMA, are here to provide technical assistance and support, and these required contract provisions are there if you are paying for the contract with federal funding. At the end of the day, the contract that you enter into with your contractor, it's a private sector endeavor, right? So it's one that you have the discretion how you do it. You just need to understand the consequences if you don't follow certain things. So we can provide technical assistance in terms of what the rules are, but also want to be careful with, for example, we cannot provide any technical assistance or support on any contract provisions that are not those that are required based on the rules. So just wanted to make sure that we provide that clarification. We're also not your legal advisors, which is why it's incredibly important that you do get your legal advisors involved, because neither Nevada nor FEMA can provide legal advice. We can provide technical assistance. We can engage with your counsel related to the required contract provisions. But ultimately, this is a private sector contract that you're entering into. So it's ultimately your responsibility to ensure that those required contract provisions are there and that you've done everything that you needed to do to comply with the rules. But again, you're not alone. So part of those responsibilities is just reaching out to us, making sure that you are aware of the points of contact that are available to you, which there are many. But then also the resources so that you can get the support that you need to ensure that you are meeting all of those requirements. I'm going to take a quick pause just to see if there are any questions. And also, I didn't mention this at the top, but please don't feel like you need to reserve your questions until the very end. We appreciate questions as we're going through the presentation. Likely, if you have the question, it is very possible that somebody else in the group has the same question. And so it's not just to your benefit, but probably for a lot of other people to provide clarification where it might be needed. And then also, if you're asking the questions as we're going, there's the context, right? And so it'll be fresh on everybody's mind in terms of what the question relates to, so that it has more of an impact and benefit. So please feel free to ask questions as you're going along. Use the raise hand function. I'll see that and be able to pause, or also feel free to post your question in the chat if that is more comfortable. Okay, and with that, we'll keep on going then. Now we'll get into the meat of it. The required contract provisions. Next slide, please. And so, as I mentioned at the very top, for any grants that are awarded post that November 2020 date, the rules are going to be found in 2 CFR 200.327. The contract provisions are, Sam mentioned this, these are required of both state and non-state entities. And so they're required of the entity that is conducting that procurement when you are using federal funding. So there are 13 required contract provisions and 8 that are recommended. Whether they're applicable, and as you heard earlier, not all of them are always going to be applicable. So this is part of what we want to discuss and make sure that, again, this is not going to be necessarily, something that you'll remember 3-4 weeks from now, even more 6 months from now. But again, so that you remember that there are applicability rules, that not all of them apply, and so that you go back to the resources or you reach out to us. And so that applicability is going to depend on the type of work, the type of contract, the contract amount that is out there, the entity type, as well as the type of grant. There on the right, you see a picture of the contract provisions guide. So this is one of the resources that we have available from FEMA. So FEMA issued this contract guide. It's issued by the Procurement Disaster Assistance Team out of headquarters. The latest version was in June 2021, so it does consider the change in the rules. And it goes through all of the required contract provisions when they're required. It goes through those applicability requirements, as well as for some of them provide suggested language or required language, because some of them also do have required language that you must include. So that is a very good resource to have. Again, go to your favorite search engine, type in PDAT, so Procurement Disaster Assistance Team, and contract provisions guide or contract guide, and the search results will come up, and it'll be in a PDF. So I would go ahead and search that after this training, save it into your favorites so that you always have that handy. Next. All right, required contract provisions, mentioned that there are 13 that are required. We've only numbered 10 of them. The Davis-Bacon Act, Copeland Anti-Kickback Act, and the rights to inventions made under a contract or agreement, they're largely not going to be applicable to the grants, the mitigation grants that you are dealing with, which is why I have them in shaded, and they're not numbered. Just want to make sure that you know that they are out there. They are required for certain types of contract. We are not going to go through them in detail during this training because we have a limited time. However, and I think Janelle might share the slide deck after the fact in PDF. There are 3 slides at the end that provide some information on them. And again, detailed information is available in that contract guide. And I'm going to take a pause because I saw that there are a couple questions. So the first one that we have in the chat is, what are the RFP requirements if it is a sole source provider because of technical requirements? Tori, can you come on and maybe provide more context on the question?
Hello?
Yes.
Hi. So I was just wondering, cybersecurity things are, highly technical, right? And so I don't even know if this is the case, but I was just asking the question, what if we were in a situation where, we have a certain kind of technology that is specifically what we need because that's what we have everywhere else? So if something did turn into like a sole source provider, what would be the requirements associated with the RFP?
Got it. Okay. Thank you for explaining. I appreciate you coming on. So the requirements on the RFP will be, I think, specific to the scope of the work that you need. But then also are covered by, there is a provision within the procurement rules that provide you with general knowledge, or general guidance. The procurement rules in terms of what must be required in the RFP are not as prescriptive, other than a few big no-nos. For example, it's one of the things that cannot be in a solicitation is that you cannot identify, for example, a brand, and there cannot be any geographic preferences unless there's a licensing requirement attached to it. For example, engineers need to be licensed in the state in which they're operating, and so then the geographic preference is acceptable because it's tied to a license. That is a different training though, because these contract provisions that we're discussing today don't go to the substantive scope of work, but more to are general to protecting taxpayer dollars generally. So that's a little bit of a different conversation, but there are some high level requirements in the rules for RFPs. I think the biggest thing is making sure that you're not excluding anybody. And then sole sourcing is, if you're doing an RFP, then you're not sole sourcing. If you want to sole source, there is an exception when the technology is only available, or the product or service is only available from one source, but that is a very, very high bar, because it really applies where we've seen it applies. For example, just one company has the patent to this one type of software and technology. And so nobody else can access it because there's that patent there that's protecting that. But then likewise, it is absolutely required for the work that you're going to do, and something comparable or something different is not going to meet the mail. So those it's a very high bar for sole sourcing based on just one single source. Okay,
Thank
and
you.
then yeah, no problem. And then we have another question in the chat. If purchases are being made that will not be under a contract, do the provisions need to be attached to a purchase order? So when there are purchases that are under the threshold, you don't always need to have all of these contract provisions. So if you're doing a micro purchase that's under $10,000, the contract provisions are not necessarily going to be required. If you're doing a purchase under the small acquisition threshold, which right now federally it's $250,000, then yes, these provisions will be required. And then I see a hand up, but we're going to go also, by the way, we're going to go through all of these in detail, in more detail. So I can also answer these questions as we're going through. And then we have a hand up from Steve.
Yes, hi. A question, if we have an established vendor, we did an RFP 6 months ago to buy a product, and then we receive grant money, and we want to expand the use of this. We've already established all the provisions, et cetera, and then there's a change. Would we have to redo the contract to include this?
Yes, if you want to use federal grant funding to pay for the services or equipment or products that are involved, you will need to then make an amendment to the contract to ensure that the contractor is submitting to all of these provisions and requirements.
Okay. I was just curious because I was looking through Appendix 2 to Section 327 that has all the requirements, and I didn't see the new domestic preference in there. So I got concerned.
Yes, you want to include it. The domestic preference is one that is not in the appendix itself, but it is one that is found in another piece of legislature. And so one of the things that FEMA is doing is to have a required contract provision in the contract, so that we are ensuring that any contractors that you're using and that you are also complying with this requirement that is in law elsewhere. So that requirement is in law, but it's elsewhere in law. It's also something that FEMA doesn't have the discretion to waive.
Okay. Thank you.
Yep, no problem. Okay. Next slide, please. All right, and I mentioned at the very top that we have required contract provisions, and then we also have recommended contract provisions. Those recommended contract provisions are also in that guide, in that contract provisions guide that I highlighted a couple slides ago, that you should go and bookmark so you have easy access to it. I'm not going to go through those in detail because they're not required, they're recommended, but they, one, I wanted to flag them for your awareness, and they are in that guide available for you, both in terms of what the provisions are, if there's any template language, and the reason why they are important. Okay. First required contract provision that we have is goes to remedies. And Steve, you still have your hand up. Is that left over, or do you have a new question?
No, sorry. I thought it would go away. I guess it didn't. Now
Okay,
it's gone.
no worries. Just wanted to check in case something else came up. All right. So the first one that we have is related to remedies, and the requirement is that any contract that you have, or a contract that you have that is above the simplified acquisition threshold that's there at the bottom, you must address any administrative, contractual, or legal remedies in instances where the contractor breaches the contract. So where the contract doesn't comply with one of the terms of your contract. And it must provide for sanctions and penalties. So this is a way to ensure that, again, taxpayer dollars are being protected, so that if the contractor doesn't meet one of your requirements in the contract, for example, doesn't perform to what the terms of the contract are, is way late, you have an ability to enforce compliance and to encourage the contractor to meet the timetables, to meet the scope of work that is outlined, or their obligations that are there. And so this is why the federal government requires that you have a remedies. This is to protect federal taxpayer. This is very standard in any contract. Really, before FEMA, I was an attorney in the private sector, and I worked in transactional deals and also in litigation. So I've litigated many contracts that did not have contract provisions, but I've also written contracts, and this is pretty standard. So generally, you should always have this. But certainly, when you're spending taxpayer dollars, you need to make sure that there are remedies to enforce compliance by the contractor, or to hold them accountable if they don't comply with the terms of the agreement. The applicability, as I mentioned, is that this applies to all contracts that are above the federal simplified acquisition threshold. The federal simplified acquisition threshold is $250,000 right now. So for any contracts that you have that are above $250,000, you're going to require this. This provision is required. There is no suggested or required language that is available in the contract guide. All right, next one. And actually, I'm gonna link, I see some chat regarding the guide. I just put in the link to it, to the FEMA website. So bookmark it there. It's that link will take you to the contract provisions guide. Okay, good. Number 2, termination for cause and convenience. So the requirement here is that contracts must address your ability to terminate the contract, both for cause. For example, there was a breach, so that would be one of the remedies. The contractor did not meet one of their obligations. They did not provide the equipment that they were supposed to. They did not do the work on the timetable that was required. They did not do the work. So you should be able to terminate the contract for cause because there was a breach, but then also for convenience. And the provision must also provide how you will terminate the contract and the basis for settlement. This applies to all contracts above $10,000. And we don't have any suggested or required language that is available in that contract guide. An example of why this is important, and I've seen this provision come up play, and it became a huge issue for over millions of dollars for one of our recipients. So there was a state that was being proactive and preparing congregate sheltering for evacuation due to an impending hurricane. The hurricane was coming up the East Coast of the United States, and as I said, the state had a contract for a prepositioned contract for sheltering for the evacuations that they were expecting. And so the contractor was supposed to come in, set up with temporary sheltering, providing water, sanitation services, food hall, some privacy areas, etc. All of the things that might be required when you have to evacuate a large number of people. And there was also the part of the contract also, or the contract also covered then bringing this down, right? After the storm, once people are evacuated, they can go back home. You're going to have to bring all this down. And so there was a significant amount of money. It was millions of dollars that this contract was. The hurricane, as hurricanes are did not keep its track that was expected. It made a sudden turn, and it completely missed the state that was preparing for this contract, or that was preparing for this evacuation, which was great, right? No disaster, no declaration, crisis averted. However, the state did not have one of this required contract provision. It did not have a termination for cause and convenience clause in its contract, which meant that once the hurricane turned, the state did not have the ability to terminate the contract for convenience, right? There was no cause. The contractor didn't do anything wrong, but the state no longer needed the contract. It no longer needed to spend millions of dollars setting up sheltering for evacuees because the hurricane completely missed them. However, because this clause was not in the contract, that state was still required to move forward because, as I mentioned at the very top, ultimately, while there are all these contract provisions, the contract is a transaction between the subrecipient or the state and that contractor. It is a private transaction. And so all of the terms of the contract still must be followed, even when there isn't taxpayer dollars that we're covering, right? Federal funding that was covering. So now the state was on the hook to pay for all this money. There's no declaration, there's no federal funding coming through, and it became a big issue in terms of whether FEMA was going to reimburse this expense, being that the state did not have one of the required contract provisions. The state had not complied with the procurement regulations. So this was a very real world example of what can happen if you don't have one of these contract provisions, and this one specific. All right, so that's why termination for cost and convenience is incredibly important. You want to be able to, again, protect those taxpayer dollars. If for whatever reason you no longer need the contract, you want to be able to get out of it. Stan?
Hi, I just wanted to just weigh in here just for a second, because I've seen a few contracts come through across my desk that have a termination for convenience clause. However, within the clause, it'll say that it can be terminated for convenience after, say, 3 or 6 months of payments. You know, it's like a longer term contract, but there's this requirement that you make 3 to 6 months of payments before you can terminate for convenience. And, you know, my interpretation was that's not really a termination for convenience provision in the way that I think the guide had intended. I just wondered if you had come across any of these in your work and how you were approaching them.
Yeah, so yes, I've seen those. If they have the clause in place, it is technically in compliance by the letter of the law, because the regulations don't have required language, right? So they don't prescribe what type of termination is appropriate. And so by the letter of the law, that provision, we could say it's compliant. However, to your point, it doesn't really follow the spirit of the law, because the spirit of the law really is to protect taxpayer dollars. And so in the event that something does happen, you should have the ability to close out on the contract quickly. However, if the private parties to the contract choose to frame their termination clause in this way, then in such an instance, for example, where it's like, you know, maybe days after, let's not say 6 months, but maybe the state did have a contract provision that said this many days after provision of services, there could be a better argument to be made that they complied with the regulations, and therefore the taxpayer dollars or FEMA is not as likely to question the costs. But it still puts you at risk if something does happen and say FEMA finds that something wasn't reasonable for whatever reason. There could be more of the potential that you might be on the hook for that money. But it does, by the letter of the law, it's fine.
That's incredibly helpful. Thank you.
Mm-hmm. Okay. Number 3, equal employment opportunity. So with this requirement, contracts are required to include language that contractors will not discriminate against any applicant for employment or any employee that they bring on board because of race, color, religion, sex, sexual orientation, gender identity, or national origin. I remember at the very top, I mentioned that there's generally two objectives, reasonable cost and protecting taxpayer dollars, but then also other policy considerations. This is one of those other policy considerations. It's equity and our obligation under the Constitution not to, under the law, not to discriminate. So this is where this comes in. Oh, we lost the slides. Okay, there we go. Thank you. And so this is the why for this language. So if you're paying for a contract with taxpayer dollars and you're bringing on a contractor to do construction work, that contractor has to agree that they will not discriminate in their hiring. So you're not doing the hiring, but the contractor that you bring on board is doing the hiring and bringing on employees or consultants or contractors, subcontractors to do their own work. In doing that, they cannot discriminate. This applies only for construction work contracts. So if the contract is not for construction work, let's say it's for engineering services, or there is a consult, the contract is for scientific feedback, right, for research and consultancy, then this requirement doesn't apply. But if you're contracting out for construction work, you have to ensure that this provision applies, and note that there's no dollar amount for it. And there is, in that contract guide, there is required language, because this requirement comes from another law. And so that other law does have the required language that should be included, but it's in the guide. Okay, next slide. Number 4, contract work hours and safety standards. This is again for the objective there is to protect the people who are going to be working under the contract, right? This is just more of a societal provision, and so must include a provision for compliance with statutory requirements on work hours based on 40-hour work week and safety standards. So again, this is to make sure that contractors or workers, employees that are brought on board are paid fairly, that they're paid based on the 4-hour work week, and that the standards that the contractor is going to set are based on general safety standards, so that the workers are protected and are not put in dangerous situations when they're doing construction work. And so this one applies to all contracts that are above $100,000 that involve the employment of mechanics, laborers, or construction work. And there is required language. Again, this comes from another law, and so there is, that law provides required language, and we have included that in the contract provisions guide. So you don't have to go to another place to find out what the required language is. It's there in the guide. Have a question on the chat related to whether the contract has to contain all parts of the required language for the equal employment and opportunity. Yes. So if you have if that provision applies because you have construction work, you want to make sure that you are putting in the language exactly as it is. Again, it's a copy and paste. But you do want to make sure that all of those provisions are in the contract. All of those paragraphs are in the provision in the contract, I should say. Did that address the question, Heather?
Yes, it sure did. Thank you.
Okay, perfect. Next one is Clean Air Act and Federal Water Pollution Control Act. So again, contractors must comply with Clean Air Act and Federal Water Pollution Act, and any violations must be reported to FEMA and the Environmental Protection Agency, the EPA. This applies to all contracts that are over $250,000, and the guide does include suggested language, and so this is part of the United States policy in terms of environmental protection, protecting our waterways, protecting our air. So this comes from those other set of laws. And anytime that you have a contract above $150,000, you want to make sure that you're including that provision in your contract. The contract guide also has suggested language that likewise you can just copy and paste. All right. Number 6, debarment and suspension. And sorry, I'm also scrolling through the guide to make sure that I'm looking if there's anything else that I want to point out for you all. So if you see me looking away from the screen, that's why. And then also when I was answering Heather's question, I was referencing the contract guide. All right, so debarment and suspension. This is about making sure that the contractors whom you're awarding to are responsible contractors. So, taking it to the practical perspective, let's say that this is your money and you're getting work done in your house. So you need somebody to come and do your backyard landscaping. So one of the things that you're going to do in identifying vendors is first you're going to kind of educate yourself and have an estimate of what the price might be so that when the contractor is providing you with a quote, you can assess it against something. But then also when you are looking for potential contractors, you're going to do your research to make sure that they are responsible contractors, that they have a good reputation, that they have good reviews, that they're in the Better Business Bureau. They don't have a low score. You're going to check references. So you're going to do your due diligence to make sure that the contractor who you're paying maybe $10,000, $20,000 of your hard-earned money is somebody who is responsible and who's going to provide the services as required. And so this is similar from the federal government perspective, especially because the federal government contracts are a lot more money. And so the government wants to make sure that when we're awarding contracts, that we're awarding those contracts to responsible contractors, that we have a fairly good, a reasonable expectation that this contractor is going to deliver as required and has a reputation and a built performance where they are known and have proven themselves to deliver. And so you want to make sure, one of the things you want to make sure to do is that the contractor is in compliance with debarment and suspension regulations, that the contractor is not suspended or debarred. And so you want to go check on SAM.gov that the contractor is not suspended or debarred. But then also that the contractor, oftentimes these contracts are big and they might get subcontractors. So you want that contractor, that primary contractor, to also ensure that if they're bringing on board any subcontractors, that they're also ensuring that those subcontractors are responsible vendors, responsible contractors, and so that these subcontractors are not suspended or debarred. This provision applies to all contracts and subcontracts that are over $25,000 that require the consent of the federal agency, and all contracts for federally required audit services. And there is suggested language there. All right, and Debbie has a comment that it's above 250,000 or 150,000. Debbie, do you know what, are you referencing this one or something else? Clean air, okay, got it. Thank you. Bird Anti-Lobbying Act. So this provision is about ensuring that through the expenditure of taxpayer dollars, we are not using taxpayer dollars inadvertently to lobby the federal government to do X, Y, or Z. And so within those contracts, we must include a provision that we prohibit the use of federally appropriated funds to influence officers or employees of the federal government, and the contractors must file the required certification. So again, this is to ensure that if there is taxpayer dollars involved, that if there is federal funding, there's no undue influence of federal officials through that money to maintain the integrity of the federal government. This applies to all contracts and subcontracts that are over $100,000. And there is suggested language for the provision that goes in the contract, but then there is also the required certification that the contractors must file. So this is one of those instances that if this provision applies because the contract is above $100,000, you want to be careful, because this is one where it's not going to be enough to copy and paste or just to have an addendum that you plaster onto every contract, because on top of the addendum, you're also going to need to ensure that the contractor signs the required certification. So the required certification is language that you can copy and paste, but that will require a separate signature. And so you want to make sure that you're tracking that. Next one. All right, procurement of recovered materials. This is another one that's like an environmental provision. This is like what I call the recycling provision, if you will. And so want to make sure that we're complying, that those contracts are complying with Solid Waste Disposal Act. And so that you're only procuring certain items that contain recovered materials. And you want to maximize you want to ensure that waste management services are maximizing energy and resource energy, and establishing an affirmative procurement program of recovered materials. This is an EPA requirement. It's not a FEMA requirement. Again, as I mentioned at the top, these OMB rules, these are now FEMA rules. These are OMB rules, Office of Management and Budget. So they apply across the federal government to any grant dollars. So there are some rules that are, for example, more EPA based. This is one of them. So this applies to all contracts and subcontracts over $100,000. There is suggested language for it, but there's also, there's suggested language, sorry, that was a mistake. No required certification. Let me check that. Yep, suggested language, scratch the required certification. That was a mistake on my part. All right, next one. Prohibition on covered telecom equipment or services. This is a newer law. So this also came out in 2020. So this is one of the new things that changed. And so it prohibits the obligation or expenditure of federal funds on covered telecommunication projects from two specific companies that are Chinese companies. And these are Huawei, and I'm sorry, I actually don't know how to say that name, and then ZTE Corporation. And this is for national security reasons. And so the government put in place that no taxpayer dollars can go towards buying products, telecom products from these two companies. This is going to apply to all contracts in support of disaster declarations or awards issued after November 12, 2020. So if your mitigation award is not tied to a disaster declaration, this one doesn't apply. And there is suggested language in the guide. Next one is domestic preferences for procurement. This is also a newer one. And Steve asked the question about it earlier. So this is a requirement that comes from another law. And so, and it's to the greatest extent possible and practicable. If you're using federal taxpayer dollars, if you're using federal funding, you should provide a preference to procuring goods, products, materials produced in the United States. So that there is suggested language in the contract guide, but again, it's to the greatest extent practicable, you need to provide preference to procuring goods. And so you want to put this in the contract because obviously you're not doing the contract, you're getting a contractor to do the work, and within that, the contractor is going to be purchasing products, material, equipment, goods to conduct the work. And so that contractor then has a responsibility and is bound by the procurement, by the contract provisions to ensure that when they're purchasing those goods, that equipment, those materials, that they are giving a preference to ones that are made in the US, produced in the US. All right. Tools and resources. So as I mentioned at the very beginning, this is a lot of information. You're not going to retain it all. However, the biggest thing is for you to have awareness that there is required contract provisions, the why we have those contract provisions. And so that when you're going through the process, you're remembering that and then going back to the resources that we have. And so at the very top, I mentioned the 2 CFR 200 and the resource that I use to be able to identify, to go back and reference the rules, which is always going to be your first point of attack. You always want to go back to the source, and that's going to be the rules. That's www.ecfr.gov. Bookmark it, but again, if you don't bookmark it, an easy way to get it is go through your search engine, your favorite search engine, type in 2 CFR Part 200, and typically the first result will be the ECFR website. The rules are 2 CFR 200.317 to 327. And remember, there is that tool on the left-hand side of the menu bar where there is a date function. So you can input the date of the when the award was granted, or if it's a disaster, when the declaration was made, you input that date, and you click on go to. Remember to click on go to, because if you don't, it won't actually do this. And then that will provide you with the rules that were applicable on that specific date. And this is important because the rules changed in November 2020, including the rule number for the procurement rules. It used to be 326, now it's 327. You have the PDOT website, so it's www.fema.gov/grants/procurement, and there mentioned the contract provisions template. That's the link that we included in the chat. So that tool is there. There's also webinar series that they have. There's fact sheets, there's checklists. So Nevada has their own checklist. FEMA also has a checklist that you can use. But certainly, I think if Nevada has a checklist, I would go ahead and use what Nevada has over anything that FEMA has on its website, because Nevada has worked on that checklist based on what we have provided to and to incorporate any particular requirements that Nevada also has. Because with the procurement rules, and this is beyond contract provisions, but just as a reminder for everybody, if you're a subrecipient, if you're a non-state entity, you want to ensure that you're following the federal rules, but you also must follow Nevada rules, anything that's specific to Nevada, and then your own rules that you might have. But there are various tools that are available there, so make sure to check it out. And then if you have any questions, you can email askcsid@fema.dhs.gov, and any such questions will go to the PDAT team that is at headquarters, that Procurement Disaster Assistance team that creates all of the resources that I just mentioned. And then next, you also have points of contact, and make use of them. So you have me, Angie Saavedra. I'm Division Director here in Grants in Region 9. We're there to support you. Megan Bryant is the Grant Services Branch Chief in my division. She was not able to make it today. She had a conflict, but she is probably your first point of contact. If you have any questions, Sam Laddick, Senior Deputy Attorney General, this is her email address. She's also available. But really, I think first and foremost, before you reach out to us, reach out to Janelle and her team. They have a lot of information. They have a lot of knowledge. They've been working with us a while. So if they're not able to address your question, they can elevate to Sam or to us as appropriate. But really, your first point of contact should be Nevada and your partners there in the state through Janelle's group. And I believe that's all I have for today. Open it up for any questions that we might have. Janelle, anything else? Janelle, Sam, anything else that you all might want to add?
Hey, this is Sam. Just because I can, I want to hold this up. This is the contracts for, if you don't have this on your desk printed off and you're using it as you work through your contracts, you're definitely you don't have all the information you probably need. I know I rely on this guide on a regular basis. So if you haven't printed that off or keep it on your bookmark or whatever, please do that. It's been such a great resource for me, and I think it'll help you as you navigate this contract process. And it may answer a lot of the questions that you have. So that's just my plug for the contracts provisions guide. And thank you, Angie, for being here today. That was so helpful. And thanks for letting me be here.
And I will just add, thank you to everybody. Thank you to Angie. Thank you to Samantha, and everybody for attending this. We will send out, we did record this and we're working on, this is a technical disaster day, it seems like, I guess here at our agency anyway, but we are trying to post these, so we will make them available as soon as possible, and we'll let you know when that happens. We're also going to email out the information that we were unable to attach to this. And that's all I have, but I do see there's at least one hand up. I'm not sure who that is. Steve.
Yeah, I'm one of them. You may have just answered my question. Is the contract provisions guide going to be something that you're going to email out to us?
Yes, we'll copy that as well. And then, of course, in that chat, Angie did thankfully attach the link to it, so you can link to it if you want to, and then go ahead and print it out for there, but we will email it.
All right. Thank you very much.
As far as, and along with our checklist. And then please reach out to us if there's anything else that you guys need and you don't get it for some reason. I believe we got everybody's email that didn't register for this, so we can add those emails to the ones we have, send out the documentation. And Angie, once again, great presentation, and we thank you very much for making yourself available to us. We so appreciate that.
It's my pleasure. Thank you so much for inviting us. We really appreciate the opportunities to talk procurement and anything grants related. So if there are any more requests, keep them coming. We're happy to preach. And thanks to you and Sam, really appreciate the partnership with this presentation.
Yeah, will do. And then are there any more last minute questions? I'm not seeing anything. So we are done. It's only 10:15. I wasn't sure how long we were going to need for this, so I just put a time and figured everybody would be happy if they got time back. So enjoy the rest of your day, everybody, and we will meet again the next time that we are planning one of these kinds of webinars. So thanks, everyone.
Thank you.
Bye. Thank you.
Thank you.